Well, welcome everybody. I'm Martha Shapiro and I am the Director of Programs here at Senior Concerns. For those of you that might not be familiar with Senior Concerns, we offer lots of services for older adults and family caregivers in the Conejo Valley. We offer the Meals on Wheels program. We have an adult daycare program here on site. We also have senior advocates, a caregiver resource center, and legal and financial concerns, which you'll hear a little bit about today. So if you're not familiar, please check out our website and give us a call. We have started a new series of seminars that are all based on different legal topics that are important for older adults and family caregivers. And I'm really excited about our topic today called What I Don't Know, Preparing for and Avoiding Legal Concerns as We Age. And having worked in this field for 15 years, I hear all too often when it's sort of that too late time, and people say they wish they had known this sooner. So by attending today, hopefully you're going to get ahead and avoid some of those issues in the future. So our wonderful speaker today is Christopher Young. He is an attorney with the Alvarez firm. He's certified as a specialist in estate planning, trust, and probate law by the State Bar of California Board of Legal Specialization. His practice is focused on elder law, estate planning, probate, and trust administration. Mr. Young's unique expertise in elder law includes Medi-Cal and veterans pension, planning to address the high costs of long-term care, special needs trust for those with a disabled family member, conservatorships, and other legal tools vital to ensuring that families are protected during a period of medical crisis or incapacity. He's one of the few experts that are addressing these highly specialized, vital areas of law in Ventura County. We're so happy to have him with us today, so we'll get right to it, and I'll turn it over to you. Thank you.
Thank you very much, Martha. And thank you to you and your excellent team at Senior Concerns for doing this series and for allowing these important topics to be addressed, because there are just like you, there's so many people that come to me after it's too late and say, boy, I wish I'd known earlier. So that'll be a theme today. But sometimes I get to the end of presentation and people say, now, who are you again? So just a little bit about my firm. Again, I practice in these areas that Martha mentioned, also litigation to resolve disputes. We work really hard to resolve family disputes that come up, but sometimes it's unavoidable. So we help, or we try to avoid them, but if they can't be avoided, we try to resolve them as painlessly as possible for people. Other attorneys at my firm also work in business and real estate law. So if you have any of those needs, feel free to reach out to me about those. And as Martha mentioned, I'm certified by the bar in this area. So that takes extra education and testing. You make sure that an attorney you work with has that designation, if at all possible, so that you can be confident that they're up to date on all the law in this area. Again, just a little more about me. Some people like to know that I've been playing this since I was 4. That's my fiddle. It's a fiddle if you're in a bar, and it's a violin everywhere else. And I'm from this beautiful Rose City up in Portland, where I was this past weekend, and they had better weather than us. That's Mount Hood in the background. But about a little over 10 years ago, I moved to beautiful Ventura County because of this lovely lady, my wife, Sarah, and our 5 little kids. That's a fairly recent photo. So remember Sarah's name. There's going to be a quiz on that at the end, but she is why I'm down here and very happy practicing elder law and estate planning in this area. So speaking of quizzes, sometimes it's good to answer a true and false question and test our knowledge. So I won't have the benefit of seeing raised hands or anything, but just test yourself. I'm going to ask a few questions throughout the presentation. These are common misconceptions or common areas of confusion for people. So we're going to do our best to clear them up today. First, true or false, and this is kind of the foundational question for all the things that we're talking about today, is how late is too late, and is a diagnosis of dementia something that limits our ability to sign legal documents? And the answer to that is false, but that's a surprise to a lot of people. Getting the diagnosis of dementia does not mean that it's too late. What it means necessarily, I'm sorry, it's not the diagnosis that makes it too late. What matters is how we're doing. And so I like to think of capacity. Well, let's just talk about how most people think of capacity. And that is in terms of like a light switch. We either have capacity, we're either on or we're off. People think very, very much in terms of just simply on or off. And what the reality is, and what Martha sees, I'm sure, and what all of us who have encountered people with diminished capacity is more like this. It's a dimmer switch. It starts at full brightness, we hope, and then at some point we may start losing that brightness and losing that capacity, and it might start diminishing over time. Some people faster, some people slower. And that's the reality, is that we're all different. And so our switches may look more or less like an on or off, or they might have more of a slow progression attached to them. So it's important to think of capacity in terms of this and catch things as early as possible, because like I said, a diagnosis in and of itself is not the end of the line when it comes to taking care of our affairs. It in many cases is a red flag to say, get into an attorney as soon as possible and do whatever you possibly can. Personally, I wish that capacity was like this, and we could just simply have a timer and know when it's going to go off and all be prepared. But the reality is life isn't like that. So we have to do what we can to use the information we have and to be as prepared as possible. So without getting too far into the weeds, I just want to point to the law on this. This is California Probate Code, which is where all the definitions having to do with capacity are found. And Probate Code 810A says that there is a rebuttable presumption that we all have capacity to make decisions and to be responsible for those decisions. That's really important. It means that we start from a place where everyone has capacity, but then there's that word rebuttable, which means that there may be evidence to the contrary. But for the sake of argument, we all start with capacity. And interestingly, even someone who has mental or physical disorder may still be capable of doing all of the things that you see on the screen there, including making wills and trusts, but even marrying and making medical decisions, all of those things, even if you have a diagnosis. In fact, the law goes so far as to say a deficit in these areas is what matters, not the diagnosis. If you see that red part, it says that there must be an actual deficit. The diagnosis is simply a marker on the field, but it is not the determining factor. And frankly, there's a lot of people walking around today that do not have diagnoses that should not be signing legal documents. And conversely, there's people with diagnoses who are very early on and may very well be able to do things. So just keep that in the back of your mind, because I think it's important to think in terms of capacity or diagnosis is a warning sign, a very strong warning sign to get things done, but it's not the end of the line. But as we face incapacity, which all of us do to a greater or lesser degree as we age, it's important to understand the documents that transfer control to others. And those are the documents I want to talk about today and focus on and take your questions about. The main documents that we consider are your advanced healthcare directive, okay, a financial power of attorney. These are, in my mind, and I'm giving away the answer to a question that's coming up, the most important documents that we can have. Trusts and wills, but keep in mind that a will only works when we die. So it does transfer control, but it doesn't do everything some people think it might do. So we'll talk about that. But like I said, the most important thing that we can do is and this is a difference between elder law and standard estate planning. And a lot of people ask me, what's the difference? Elder law attorneys, we care about what goes where when you pass away and how many taxes get paid and all of that. But we really, really focus on making sure that you, while you are living, have the people in place and the documents in place to make sure you're going to be cared for. That's what is absolutely vital. And the who gets what when we die is secondary, still important, but secondary to that. So here's another true or false question. Every adult should have an advanced healthcare directive. And before we get to the answer, I just want to point out that that word advance, a lot of people write it as advanced, and that makes perfect sense in one way, but it is an advanced directive without a D. And the reason is, think in terms of giving instructions to someone, a doctor or someone else, in advance. That's what an advanced directive is. It is also very advanced depending on who drafts it, but that's not what we look at. So it's an advanced directive without the D. And it's my opinion, and a lot of, and most elder law attorneys' opinion, that that is true. Every adult. And the reason is, as soon as someone turns 18, they are an adult under the law. And so our parents have less authority, or we as parents have less authority to make decisions affecting their health care and certainly end of life should there be an accident or something like that. So we want to make sure that the right people are authorized to do things for us. But as we age, it gets much, much more important. So maybe not 18, but certainly by the time we're to middle age or beyond, everyone should have an advanced directive. And so what is an advanced directive? Well, there are two main players. They are the principal and the agent. So you'll hear those terms. Principal is the person that's giving the power. If it's our advanced directive, that's us. And the agent is the person receiving the power, the person we're asking to help us. You, with an advanced directive, can make your wishes known. And there's a lot of things that are included in an advanced directive. There used to be two different documents in California, a living will, you've probably heard that term, and a power of attorney for healthcare. And the problem was with those documents that they were confusing to people, because a living will would be confused with other wills, the wills that come in when we pass away. And power of attorney for healthcare would be confused with the financial power of attorney. So those were combined into a single document. But the power of attorney for healthcare includes appointing an agent, someone to make decisions for us. That's what you see there on your screen. And then giving instructions about what we want done with regard to our healthcare, especially when it comes time to end of life. So making your wishes known is the other important part. And so naming your agent and backups, we want to do that. We want to go into the standard of care, whether we want the agent to have full discretion or we want ordinary care or extraordinary medical care. We can get into that with our document. We can address end of life care, as I mentioned. Topics like organ donation can be covered. We can nominate a conservator if one is ever needed. There are many things that you can do with an advanced directive. So let's talk a little bit about who can be our agent. The fact is that any adult can be an agent for you. Some clients have minor children and they want to put them in there. That we can't do that, but any adult can be your agent, except your supervising healthcare provider, think of your doctor, or an owner or employee of a residential care facility who's providing assistance to you. But as in the law, there's rules, there's exceptions to rules, and there are here. An exception would be if that person was your relative or your spouse or a coworker. So you can name your doctor if your doctor happens to be your wife or your husband. So those are the general rules, but it's very simple. Basic, primarily it's any adult with those exceptions. So when does the transfer of authority happen with an advanced directive? Well, the document controls. That's the beauty of it. An advanced directive, you can say what it is, and who makes the decision to transfer authority to your agent. Oftentimes, it's your primary physician who makes that decision, or your treating physician, but it doesn't have to be that way. And the key here is, when have we lost the ability to give what's called informed medical consent? And so who makes that determination and when is something that you can customize in your document. It also, that determination does not have to be in writing. And that's important to know, because in other areas, we do need a written doctor letter or something like that. But when it comes to transfer of healthcare decisional authority, it does not have to be in writing. And how long does the power last? Well, until your ability to give informed medical consent is regained, all right? Or until the death of the principal or agent, with one or a couple of exceptions here, and they're listed. And this is unusual with the power of attorney. Most powers of attorney, certainly financial ones, they stop when you pass away. But with the healthcare directive, they will continue on for a couple of purposes. One of them is to direct the distribution of or disposition of your remains, okay, so make funeral or burial plans, and also to request death certificates. So it's just kind of a unique area of the law that allows an agent to act after you've passed away for those reasons. A question I hear a lot is, what happens if I don't have an advance directive? And so the fact is that can be a really difficult thing, especially for the providers who are trying to help you, because oftentimes there's not the clarity that you would hope. And here's how that works. First of all, we always have authority to make our own decisions while we have the capacity to do so. If we're in the hospital, we can designate orally a surrogate to make decisions for us. Okay, so we can say, I want Martha to make decisions for me, and that oral designation is the second most highest priority other than me. Then comes the agent that you've named in your written advance directive. Then comes conservator, and we'll talk more about conservatorship in a little bit, but if you have a conservator, they come after your agent under a power of attorney or agent under a healthcare directive. That's something a lot of people don't realize. And then here's where it gets interesting. Your closest available relative is who they turn to. Now, if we're married, our spouse will be our closest available relative. But if we're not, if we're widowed, or if we don't have a spouse at the time, they will look to your children. And if you have more than one child, it can look a bit like this slide. And so the loudest one in the waiting room, the squeakiest hinge, will probably be the one who makes those decisions. And that may not be the person you want. So this is all to encourage you to have a written document, because you can designate with extreme clarity who you want and who you do not want. I should have mentioned that. You could actually say, under no circumstances should this person make decisions for me. And you can put that right in your document. So we plan carefully with advanced directives wherever possible. It's important to recognize that not all advanced healthcare directives are the same, but in my opinion, any healthcare directive is better than not having one at all. There is a statutory, a pre-printed form that you can get from various medical associations and hospitals and medical groups. I believe, it's my opinion, but a lot of people have brought this up as well, that the end of life decisions options that you're given in those pre-printed forms leave something to be desired. They typically make you choose between two large paragraphs, and you have to initial next to one. And they seem to be kind of the ends of the spectrum, spare no expense or pull the plug. And they don't necessarily have a lot of nuance. And many of my clients, most of my clients, want something in between. They have a more nuanced thought process as far as how they want the end of life decisions made. So with an attorney drafted advanced healthcare directive, you can be more nuanced about that. All right, so an attorney drafted one gives you more options. But going back to the top here, naming an agent is the most important thing you can do, because having somebody that can speak for you of your choosing when that time comes is vital. There have been some recent developments regarding healthcare directives. One that went into effect at the beginning of the year is that healthcare, the definition of healthcare, includes mental health. So it's good to have that clarity. So it means that your agent under your advance directive can make decisions involving your mental health. If you have dementia or other mental health conditions that affect your health, they can make those, and there's no question that they have the authority. So that was an update. And a question that I hear a lot is about, the POLST and the interplay between the POLST and the advance directive. A POLST is a physician's orders for life-sustaining treatment. It's a document that came about 25 or so years ago out of Oregon. 4 doctors up at the Oregon Health and Sciences University developed it. It can be a very good thing for people at the end of their lives to indicate that they do not want heroic measures taken to help save their lives. If they have a terminal illness or they know they're close to death, it's a very good thing to have a POLST on file. It can be a very good thing. But you also should know that it is not a replacement for a good advance directive. And as we've gone over, you can do so many things with an advance directive that you can't do with a POLST. You can't name healthcare agents in a POLST, and you can't address all the things that an advance directive can do. So primary is to have a good advance directive. Secondary would be to have a post if you're close to death or you want to have one, and make sure that it agrees with your advance directive. If you update your advance directive, update your post as well. A lot of people forget one when they update the other, and so they aren't in agreement, and that can be a concern. All right, moving on, because we're limited on time, I want to address non-medical powers of attorney. So if you are, true or false, if you are incapacitated, your spouse or child can make financial decisions on your behalf. This will come as a surprise to a lot of people, but the answer is false. Now, there is a little bit of an exception, and that has to do with property that spouses have that's jointly titled or community property. But even all community property is not able to be managed by your spouse. It really has to be in joint names. So let's talk a little bit about that and go to my follow-up question, which I alluded to earlier, which is true or false, the durable power of attorney is the most important document in an estate plan. And I would argue that it is. And the reason is that this can really bite people if they don't plan ahead. They think they have the ability to manage financial matters for their spouse or for their parent, and they don't end up having that authority. It's a real surprise for spouses, but I've been involved in conservatorships and other court proceedings where one spouse had to go to court to get authority to manage finances for their spouse because it wasn't in joint names or they didn't have the access to it. An easy example of this is retirement accounts. A retirement account by definition is going to be in the individual name of the person contributing to it, the worker. And so your spouse, even if it is community property, your spouse does not have the ability to access that account without some authority, usually in the form of some sort of power of attorney. So when a power of attorney comes to my office, it usually looks like this. That is the penknife version of a power of attorney. That's a statutory form power of attorney. It opens bank accounts and wrapping paper, but it doesn't do a whole lot beyond that. And with an elder law attorney, you're going to have a discussion at least, and you're going to end up with a power of attorney that looks more like this. And if you never need the wine opener or the toothpick, at least you had it there. At least it was there as an option, and maybe you would need it at some point. So we want to talk about all the options and all the things that can be done with a power of attorney. And that really takes a conversation with an attorney who can go over those. And the fact is that the power of attorney that is freely available is not as comprehensive as what you can have with an attorney drafted power of attorney. And there are some big exceptions, which we'll touch on. So let's talk a little bit about the financial power of attorneys and how they work. Just like the advance directive, there's two main players. There is a principal and an agent, okay? And like I mentioned, there's a statutory form. This is what that means is there's a form that the legislature in California has come up with, and it's freely available, written right out in the probate code and freely available online. I'll show you an image of it in a second so you can see what I'm talking about. The con with regard to the statutory form is that it is too general for a lot of people. And as with everything in life, there are pros and cons to financial powers of attorney, and we need to talk through those so that at least you know what the cons are. You can be aware of them and plan for and around those disadvantages. So this is what the statutory form power of attorney looks like in California. It's a little hard to read there, but it has a place for your name and the name of the person you appoint. And then it has letters A through M that are specific powers that you can give to somebody, or N, which is the power of the all of the above option. So if you initial next to N, you're saying I'm giving all of these powers. And there are some important ones there. Certainly banking, taxes, all of the basic things, real property transactions, those are all covered with a statutory form power of attorney. So like I said, it's important to have, it's better to have this than nothing at all. Absolutely. But let's talk about some of the terminology that you'll see with powers of attorney. And this was one of the items on the flyer for today, which said what one single word must be in your power of attorney for it to work when you lose capacity. And that word is durable. So if you have a power of attorney, check to make sure that it says durable. It's not exactly clear why that word and just that word has to be there, but durable means it endures past our incapacity. So it goes on even when we can no longer make decisions. So you want to make sure your power of attorney is durable. Most likely it is, but you just want to check that. Also, you'll see the term springing versus immediately effective. Springing is a highly technical legal term, which means that like a mousetrap, your power of attorney will snap into effect or spring into effect on the happening of some triggering event. So that often is a doctor or two doctors or somebody making a determination that you cannot make decisions any longer for yourself. Effective immediately speaks for itself. It means the moment you sign it, it is in effect and can be used. That statutory form that we talked about a minute ago is immediately effective. You sign it and it's off to the races. A lot of people say, which one should I use? I don't know. The fact is, if you trust the people you appoint, and you absolutely should trust the people you appoint, if you trust them to do the right thing when you can't keep an eye on them because you have lost capacity, then why not make it immediate when you can keep an eye on them and see how they do? So my thought is, in the absence, if it's 6 1/2 dozen to the other, go ahead and make it immediate. But if you have a good reason to not make it immediate and to make it only come into effect later, that's fine. Just understand that that adds an extra hurdle for your agent to be able to prove that you are at the point of needing their help. And I just want to make a quick comment about those triggers. Oftentimes I see powers of attorney and trusts, frankly, that say my agent or my trustee can come in when two physicians unrelated to me by blood or marriage certify under oath that I am incapacitated. And that is very difficult to get, especially in this day and age of managed care, to get that second physician. And note that I said physician because the problem there is that doesn't include other doctors who might be qualified to do this as well. There are some very good geriatric neuropsychologists in our county who are eminently qualified to make a determination whether we have or do not have capacity, but they are not physicians under California law. So I would encourage you to go back, if you have a power of attorney or a trust, look at it and see what the trigger is. What is the triggering event where the next person comes in and helps? If it's not death, what is it in that trust? And for your power of attorney, what is that triggering event? And if it says physician, especially if it says two physicians, consider making a modification, because again, that can add a lot of burden to the people you're asking to help and make it very difficult for them to actually get into that driver's seat and do that. So let's talk about some of those advantages and disadvantages of a power of attorney. Well, certainly the advantages are that it's economical, it's private, you don't have to go to court for it. It can be done very quickly. Don't have to get a conservatorship. It allows for management of your affairs on a trial basis. So like I said, if you don't like the job your agent's doing, then you can fire them, revoke your power of attorney, and put somebody else in charge. You don't have to change title on your assets for an agent under your power of attorney to do things for you. And it can be used in certain circumstances to create and fund trusts, which can be a very helpful thing, but it has to be very explicit authority in the power of attorney. Some of the disadvantages, and these are important. There's a lot of fraud out there. A lot of powers of attorney are misused by people, and banks and financial institutions can be very loath to accept a power of attorney, especially if it's just somebody walking in off the street trying to open an account and the bank doesn't already have a relationship with you. So the third party has to be willing to accept the power of attorney. As a note, and we'll touch on this later when we get to trust, a trust can be much easier in this area because once a bank has a relationship with your trust, it's established a trust account in your trust name. Then when a successor trustee comes in, they just show what they need to and they can get authorized to manage things. So it can be a much simpler process in a trust. But with powers of attorney, much more fraud out there. It's harder to get people to accept them. There are ways in the law that we can encourage the banks to do so, and there's tools, and we can certainly do those, but it's just an issue that we have to be aware of. Powers of attorney are often not fully understood by the people involved. Agents may not be able to give assets to themselves, and you may say, why would I ever want that? Well, even a birthday gift. They wouldn't be able to give it to themselves if that's your child. They can't do things that you would even want to do without explicit authority and in the power of attorney. And by the way, the statutory form does not give that explicit authority for gifting. So these are things to talk to an attorney about. Is this something I want or not? So interestingly, a disadvantage is the same as one of the advantages, which is there's no court involvement. So on one hand, it's cheaper and easier to use a power of attorney. On the other hand, if the person doesn't do things right, there's no simple recourse because it's not a court case. So that you have to file a lawsuit to get them to straighten things out or to account. That's not automatic. So this can be a great disadvantage when it comes to financial powers of attorney as well. And interestingly, that last item is where we get into the differences between powers of attorney and conservatorships. And that is that the principal, that's the person making the power of attorney, still retains the authority to act, sometimes to their detriment. So let's talk about that. When we make a power of attorney, we're sharing the power to do things for ourselves with a person that we've asked to help us. But we never relinquish that entirely. We still have the power to go to the bank. We just have made somebody else have that power as well. And that's different from conservatorship, because with a conservatorship, the court takes the authority away from us and vests it in someone else. So we no longer have the authority to do things for ourselves. And that's a big thing. That's a civil rights issue. It's why courts are very reluctant to grant conservatorships unless there's very, very good reason. So, but that's the single biggest difference between a power of attorney or an advanced healthcare directive and a conservatorship. And we'll talk right now about conservatorships a little more, but one, with the power of attorney, you're sharing authority, but never giving it up. And with a conservatorship, you lose that authority and someone else has it in your place. And I've seen cases where people have a great power of attorney, but then they go and they move money and they forget where it is, or they become suspicious of the people they've asked to help them because of paranoia that's part of their condition. And for those reasons, the power of attorney can stop working. It can stop being helpful, and it's to their detriment. They're harming themselves, but they don't realize it. So then the only answer is conservatorship. So let's talk about conservatorship a little bit. Well, first I just say, these are, like I said, reminder, these are the two most important documents. And without them, or if they aren't working, then we look to conservatorship and having to go to court. So when a power of attorney and advanced healthcare directive are missing or are not enough, we look to conservatorship. And what is conservatorship? There are three main kinds in California. There's probate conservatorship, limited conservatorship, and LPS conservatorship. LPS stands for the Lanterman Petrus Smith Act that has been around for a while, having to do with grave mental illness. So we won't talk much about that, but I will say that probate conservatorship is what most of us might face at some point. It's conservatorship for people that are declining in capacity due to dementia or some other reason. And limited conservatorship is one that you might see with younger people who are developmentally disabled, and they've come up through childhood and now they're turning 18, and their parents still needs to help them with basic needs, their activities of daily living and whatnot. And so limited conservatorship is something that might be granted for them, with the idea that as they get older, they might grow out of it and not need it anymore. And like I said, LPS conservatorship has to do with grave disabilities, gravely disabled people who are dangerous to themselves or others. And that actually has to be established first through the county, through the mental health department of the county. But let's talk about the probate conservatorship. There are two main kinds. There's conservatorship of the person and conservatorship of the estate. And so just as it sounds, conservatorship of the person does the things that you might be able to do with an advanced directive. Conservatorship of the estate is about protecting the finances, things that you would do with a power of attorney. It's a court process. It's involved, it's expensive and time consuming, and it involves accountings and reports to the court and an attorney appointed for the person that you're seeking to conserve. It gets very expensive, and we look to every other thing that we might be able to do to avoid those delays and costs and expenses, if at all possible. But it is there if we need it. So let's move on. Speaking of wills now, a properly drafted will, true or false, avoids the need for a probate. And this is probably the most common misconception out there. The answer is no, that's false. A will is really just a letter to a judge. Dear judge, please do this when I die with my stuff, and have this person do it. That's all it is. So it's a process, it's a court process. And it ultimately, if everything goes as planned, ends up with your estate going where you want it to go. There is a threshold in California of $184,500 for a full court probate. If you have less than that in the aggregate, in cash or non-real estate, then you may be able to administer your estate without going to court by using affidavits and other processes. That's called a small estate process. But think about this. If you own real estate in Southern California, we're looking at the gross value. It is very, very, very unlikely that you're under that number. So for anybody who owns real estate in Southern California, you probably have a probate unless you have something else set up like a trust. So we look at the gross value of the assets. What would they go on sale for tomorrow? If you put the house on the market, what would it be? That's what we care about when we're considering that number. And remember that the existence of a will does not avoid probate. Very quickly, I just want to touch on what happens if we don't have a will. In this case, there's a list of people in the law who would receive our property if we didn't have a will, and it's in this order. So first we look at surviving spouse and children, or issue, which are children and grandchildren. And I just want you to see this list. I'm not going to go through the whole thing, but I hear a lot of fear from people that they don't want the state of California to get their estate. And I just want you to see that it is the last resort. There are a lot of people that have to not be around for the state of California to get your estate. So there are some automatic provisions which protect us, but the key is there are people on this list you may very well not want to get your estate. And so it's so important to make sure you have a will or a trust to make sure that those people are not among your beneficiaries. So I just wanted to put that list there quickly. And if you have questions about that, we can certainly talk more offline about how all of that works. If you don't have an estate plan, you are in good company. You're somebody that we all know. Dr. Martin Luther King Jr. did not have a will. His family fought long and hard about two particular items of his that they all wanted. One was his Bible, and the other was his Nobel Prize. So, just bringing up a few examples of people that do not have or did not have estate plans, and where it did not work out. There ended up being a long court fight. Another is Prince. We all know Prince. He died in 2016, and just last year, after 6 years, his estate was finally settled. It was $156 million. And there are all sorts of relatives who came out of the woodwork. One of the most famous lawyers in the country, Abraham Lincoln, he died without a will, and it took a number of years to get his estate settled as well. It did go where he probably would want it to have gone, but that isn't always the case. And one example is James Dean, who died very young, as you know, and his mother raised him. His father was not involved. And then when she died, his aunt and uncle on his mother's side raised him. But when he died young, his estate went to his father because it was the default provision. So just an example of why having, planning and putting the people you want into the documents is so important. Additionally, probate is costly, lengthy, and public. And those are three things that a lot of people are not happy about. Let me give you some examples, some prices. If you have a $400,000 estate, gross value, that will result in an attorney fee of $11,000, an executor fee of $11,000, and a total there of $22,000. By way of example, $800,000 gross value, $38,000. $1 million, $46,000. All right, so think about the value of your home, the gross value of your home, and other things you might have, accounts, investments, bank accounts, and whatnot, and look at where you are on that and see, is it worth it to risk going to probate? That's something that a lot of people are surprised by. Also, the court gets fees at $435 every time a petition is filed. You have to file at least 2 in a probate to open it and close it. And there's other fees as well. So that $1 million probate could easily be $50,000 by the time all those fees are paid. And even where you do have a will, it doesn't always work out as you hope. And so another example of a lengthy and costly probate was for Marilyn Monroe. She died in 1962, and her estate was settled in, I think, 2001. So it took about 40 years to get her estate settled. And when it did get settled, the vast majority of her estate went to the second wife of her acting coach, which was not her intent if you look at the will. So working with somebody who knows all the options and make sure that we can minimize the chances of things going wrong is very important. So when we started with this list at the beginning, we talked about these 4 documents: the advance directive, powers of attorney, wills, and trusts. And the one that we haven't touched on yet is trust. So I want to do that in the time we have left. So here's another true or false question. And this is a common misconception, that trusts are only needed for people that have substantial wealth. But as you've seen, that may not be the case. So it is true that trusts are often a good idea, even if you don't have substantial wealth. There are many, many reasons, too many to go into here, why a trust might be good. I'll mention a few, though. If people have addictions, if people have a disability where they're receiving public benefits, all of these can be really simple reasons to keep even the smallest amount of money in a trust to protect that person and avoid unintentional loss of benefits or harm to the individual. But there's also reasons related to taxes and all sorts of things. So let's talk about those trusts. A trust is a legal arrangement in which a trustee holds legal property for a beneficiary, all right? So it's you hold this for me and give it back to me, or give it to the person I tell you to give it to when I don't need it anymore. That's what a trust is. It comes into effect right away when you sign it. And there are 3 main players when it comes to a trust. There's a settlor, a trustee, and a beneficiary. Sometimes you see settlor as grantor or creator. If it has the OR, that means the person who made the trust. Then the trustee is the person managing, and the beneficiary is the person who gets the benefit. When we create a trust, most likely we are all 3 of those. But over time, we may stop becoming the trustee for whatever reason. And at our deaths, at least, we'll stop becoming the beneficiary. So it's a way to help manage our money while we're alive but incapacitated, and also to get things where they're supposed to go without the cost and delay of probate when we die. As we alluded to, trusts provide many benefits. So they allow for the management of your assets at incapacity or at your death, during incapacity and at death, making sure we're protected, and then our heirs and beneficiaries are protected. They avoid those probate costs and delay. They maintain privacy and control. Unless somebody goes to court over it, nobody sees what's in your trust. It's a private contract. And like I said, there's some tax planning benefit as well if you have potentially a taxable estate from estate tax at your death. Transfer of authority happens on the same, we've talked a little bit about this, on incapacity or at death, and the incapacity trigger is what you say in the document. It can be set forth in the document. So whatever the rule is that you put in there, again, 2 doctors, 2 physicians, 1 doctor, whatever it is, that's going to be the trigger. You can have different triggers and different trustees for different situations. So I sometimes make trusts where somebody says, if I'm alive, but I'm incapacitated, I want this person helping me. But at my death, I want another person to make decisions and to get the money to my beneficiaries. So you can have all that creativity in a trust. There's many, many creative things that you can do and customize specifically to your family situation. This, unfortunately, is what I see a lot after someone passes away. This would be an unfunded trust. You may have the best, most strongest, best trust in the world, but if your shoes and your clothes are in the closet, that's not doing it any good. So a trust can only control what is in it, what has been transferred into it. And you actually have to transfer property. You have to deed your home. You have to rename your bank accounts to say that they are held by the trust. And this is vital. And there's many, many examples of cases of well-known people that didn't do this right, and they still ended up having to go to court. But the reality is, forget well-known people, it happens every day in our county with our neighbors and our friends. It doesn't get done correctly, and we still have to go to court. So it's really important to work with people who can help you not just make the trust the way you want it, but also get your property into that trust. Remember, assets not transferred are not controlled by the trust. So you got to look at the title of the property, and you may need a probate if things are not properly titled. And if assets are not in the trust, your power of attorney will still be used to control those assets. And then an executor at your death would manage those. And if assets are in the trust, then the trustee can manage those. Generally, others have no authority to manage to amend our trust, but you can give that authority in a power of attorney. And so it has to be done very carefully and correctly, but you can give that authority. And you might ask, why would I want to do that? One example is if it turns out later that somebody becomes disabled and they need to protect their public benefits, then somebody can come in and correct your trust so that, again, they don't get money that would disqualify them later on. So my question for you today is, how is your plan? Are you on the state default plan, or do you have a trust or will yourself? And think about it. If you do have a trust or will, is it doing what you want? Have you or the ones you're providing care for done what's possible to avoid conservatorship? All right, we want to avoid that because it's costly and time consuming. Do your healthcare directives indicate what your wishes are very clearly? Is your power of attorney durable, or does it give it authority to the people you trust? Does it have backups? Because we don't know what life will throw at us, and the person we've named might not be there when we need them. I have never had someone tell me when they're done with their estate planning that they wish they'd taken longer to do it. They always say, oh my gosh, I'm so glad it's done now. It's a huge relief, and I can move on to other things that I enjoy more. So if you want to be in that mode where you've checked this off your list and you can have it in your rearview mirror, then I encourage you to take this opportunity. You're here, you've gone through this process of showing up. Take the opportunity to get this done, or revisit it if you have one. And with that, I will open it up to questions, but I do want to mention before I stop sharing, there is a complimentary initial consultation, which you're free to avail yourself of. Just call or email and we'll set a time to talk offline. And I told you there'd be a quiz about my wife's name. Since I'm not great with phone numbers, it is 805-246-SARAH. And that's my wife's name. She does not have an H on her name. So 246-SARAH, and now you'll never forget the phone number to reach me. So thank you very much, Martha. And with that, I'm going to stop sharing and open it up for any questions that came up.
Well, thank you so much. It's a lot of information, which I think some of us can feel a little overwhelming, but you have a great way of explaining it so that it makes sense. And I'm sure people might want to rewatch this, and so it is being recorded, and I will send the link around. We do have a couple of questions. So the first one says, is it legal to get a form online to name someone to be my financial power of attorney?
That's a great question. I see that there. And the answer is yes. It's if you find an online form, make sure it's a California form. So I mentioned earlier, there's the state statutory form with those lines A through N, and you can initial next to any of them, or N says all of the above. That's a freely available form online. In fact, if you go to the Sacramento County Law Library, just Google that, and then power of attorney, it'll take you to a page on their website. It's just, I'm sure other law libraries have it too, but I happen to know it's there. And you can find that form and fill it in and print it and sign it with a notary, and you're off to the races. As I said, it's better to have that than nothing at all. So I strongly encourage you to start with something. But once you have it in place, then consider, is there any reason I might want to have something that's more customized to me as well? But certainly, yes, you can start with an online form. Just make sure that it's a California form like the one I described.
Perfect, thank you. And this one made me sad to hear that someone had gone through this. It says, my mom had an advanced healthcare directive. However, a local hospital would not recognize her wishes unless all family members were on the same page. The ER doctor indicated they'd been taken to court too often. My mother's wishes were not recognized as this happened over a weekend and courts were closed. How could I ensure this doesn't happen with me?
Well, first of all, I'm very sorry that happened. That should not happen. The whole point of having these documents is to avoid that very situation. And ironically, the one way to guarantee going to court is to disregard somebody's advance directive. I think that this situation, it sounds to me like a very unusual one in the fact that it was timed over a weekend. Certainly courts are not in session over weekends, but courts will be very responsive and have been, in my experience, very responsive to what we call ex parte petitions, where we go into court very quickly and say, this needs to be corrected, this needs to be fixed. And judges are very compassionate and they understand what's going on, and they will do that. I hope it can be avoided because it still involves cost, court costs and attorney costs, but there is a mechanism there. Again, I'm very sorry that situation happened to you, but I don't know a way to avoid it other than to say right in the document, I absolutely do not want this situation to happen. And I would have no problem putting that in an advance directive and saying, you must listen to my agent. And if you don't want to go to court, that's the way to do it.
Yeah, it sounds like you did the right thing. So that really surprises me as well. And absolutely horrible that in the middle of a medical crisis, you should have to seek out a court. So that's a shame. Okay, bunch of other good questions here. I made a trust before I got married. My bank accounts were in that trust. Is it difficult to now make a new trust with my husband and transfer all the accounts into the new trust with not of us? Not sure what the last part is.
Both of us, probably.
With both of us, yes, thank you.
It's no more difficult to, yes, you would need to have a new trust that would have joint provisions for both spouses. And there's a lot of advantages to having a joint trust, which you can discuss with the attorney at the time. So not just for this, but you would need to have a new trust. But I do recommend, if you made your estate plan before you got married, stuff that we didn't talk about today, but there are provisions in the law for what are called omitted spouses. So if you are married when you die and your estate plan does not mention your spouse, the spouse has a right to certain assets in our estate plan by default. So it's really important to talk about this with an attorney, even if you make no change, to at least know what's going to happen and what rights your spouse has to your property when you die. So I strongly recommend that you speak with an attorney about that. But it's a fairly straightforward process to do a joint trust and to move assets into that joint trust. And we could talk about that more if you'd like.
And I do want to mention that Mr. Young has offered a free consultation to anyone, which is amazing. And I highly recommend you all take advantage. But also Senior Concerns, as well as Camarillo Healthcare District, we offer programs, pro bono legal consultations as well with elder law attorneys like Mr. Young, who's one of them, and some other well-respected attorneys in the area. So anyone can call either to Senior Concerns or Camarillo, depending on where you live, and schedule that free consultation. So if you do have more of these individual questions, I think that's a great opportunity. They're not going to make a trust for you in that consultation, but they can guide you and answer your questions and make recommendations on what is needed.
Thank you for remembering to bring that up, Martha. It's a great resource.
A few more that I think we can probably get through pretty quickly. Can you explain what you mean by having a trust account with a bank?
Sure. When you have a trust, you need to make sure that your like I said, your assets are held in the name of that trust. So banks know about this, and you tell them, you bring paperwork in that shows the name of your trust. Every trust has a name and a birthday, the date that you made it, and that never changes, even if you change things later on. So you bring that into the bank and you say, here's my information. Please open a new account or change the name of my account, depending on the bank, to the name of my trust. And that's how we show what title is for our assets. And the same thing goes with our homes. we deed that from our own names to a trust name. So it's a process. It takes a little bit of effort, but once you've done it, you won't have to do it again.
Perfect. And then this one, she says, a big stumbling block is cost. How much does a trust cost for a couple?
Sure. This is a tough question because if I give you a number and it's higher or lower depending on the attorney, the fact is every attorney is going to charge based on their own time and how much your specific case appears that it will take. So they'll discuss that with you. If you have business interests or multiple properties or anybody with a disability in your family or anything like that, that's going to impact the cost. What I will say is this: it is going to be much, much less to do a trust than to put your estate through probate if you have a home in Southern California. So, and what I would also say is a good attorney will tell you if that's not the case. If you come in and you don't have real estate, and it would frankly be simple to just distribute your estate some other way, a good attorney will tell you that. But there are many, many advantages to having a trust in addition to the cost of avoidance. But I will say it's going to be much less expensive to do a trust, and just talk with an attorney about that and what the cost would be. It's not going to break the bank, but it's going to be different for every person. So I'd be doing a disservice if I just throw a number out.
Can you give us just a range? So we're thinking like a couple thousand, 10,000.
Yeah, I would say it's going to go up from, I mean, for a single person with one property, it's maybe in the $2,500 to $3,500 range, and it's going to go up from there based on what kind of property and how many people are involved, all of that. So, I mean, again, that's just a starting point, but compare that with the probate costs, and you start to get an idea of why it's important.
Absolutely, thank you. Is there well, I know that I can answer this too. Is there a state form for an advanced healthcare directive?
Yes.
Yes.
Yep. And as Martha can answer that. In fact, she has those forms. And if you came into the free legal clinic on you would have access to those as well. Similar to the statutory form that we talked about for the financial, you can find those online. If you're a member of Kaiser, you've probably been handed one. Many, California Medical Association, California Hospital Association, all of those have variations of that free form. And again, starting with that is fine, but then consider whether you want to get more nuanced about your wishes as well.
Yes, definitely, because there are different forms. And there's even, like, some people might have heard of the 5 wishes form. Well, that can help with some things, but you also want a form that will be still valid after the person passes away for the disposition of their remains, right?
Exactly.
That's an issue that comes up sometimes. And like, this question is, how do you make a hospital aware of your wishes? And I am part of the Ventura County Coalition for Compassionate Care, and we talk a lot about how to make your wishes known, because just having the form is not enough if you're not showing it to the people that need to see it, right? And I think there's a assumption that maybe, you've done a surgery at a hospital and they've asked you for a copy of your advance directive, so you provided it to them at that time. But a year later, you go into the ER and there's an assumption that the hospital is just going to look up in their system and see your advance directive on file. But that is not often what happens, especially in an emergency room where they don't have time for that. So I always, if you're going to the hospital, you should be grabbing that copy and taking it with you, but I'll let you.
But when my clients leave the office with their new estate plan, they leave with several extra copies of their advance directive. And I tell them, keep the rest of your estate plan to yourself. That's nobody's business until you know that you're not going to change it again. But your medical directive, that's something you should give to everybody who asks, because it's very important that you get the word out, just like you said. And give it to your doctor, have them, oftentimes they just scan it right in, because they can use that little scanner at the reception desk, and then they hand it right back to you. But make it part of your file everywhere that you go. Absolutely.
Definitely. Did you give this talk last night at 7 p.m.?
I spoke to a support group from the Alzheimer's Association at 7 last night. So I'm thinking that's what you're referring to. And,
Well,
but
I'm
a
sorry that this person missed it, but glad they got to catch you today.
little different, but a lot of the same themes.
So I know we're just about at time, but I think we can probably grab the last couple questions if you don't mind. Okay.
Available attorney in San Francisco. I see that one there. You just send me an email or give me a call. Email is best because then I can take that and look up somebody. But I know people up in that area. Just tell me the city, and I'd be happy to try to make a referral up there.
Excellent. And hopefully you've addressed this, but what happens when all members do not agree with each other?
Members of what? You mean?
I mean, all of this is to help avoid when people don't agree because you've clarified who gets to say.
Oh, I'll bet it's family members. If family donors, that's why it's so important to have the document, because you pick who you want to be making the decisions. And if somebody disagrees, well, if they're not the person you pick, then they don't get a say. And I think that's vital, because the alternative is that it's going to be the person shouting the loudest, the squeakiest hinge, and that may not be the person you want. So, oftentimes family members don't agree, and that's why it's so important to pick one person to be the spokesperson.
And sometimes it's not the most obvious person in your life, that's going to be able to carry out your wishes the way you want. That person might be too emotional or too upset or want to do all the life-saving things that you don't want. So it's something to really think about and talk about when you're making this plan.
Yep.
And once a trust is established, I feel like this one's talking to me. How often should you review the trust with their attorney?
It's going to be a case-by-case basis. There's two things that cause a trust or an estate plan to need to be changed. One is changes in your family, and the other is changes in the law. You're not going to know all the changes in the law. So a frequent check-in of at least every 5 years, just to check and, blow the dust off the estate plan, pop the hood, and make sure everything is still going to work is a good idea. And then changes in your family are the biggest reason I see people come back, because, they had somebody pass away that they wanted to leave something to, or some other circumstance that changed.
Perfect, thank you. Once I get this all uploaded, I will send everybody that registered a copy of this presentation along with the contact information for Mr. Young. And so if you would like a copy of the slides, you are welcome to send him an email, and he can provide those to you. So I want to really thank you so much for joining us today. This is such important information, and I think hopefully everybody walked away knowing something new. I know I always do. This legal series will continue through this year at least, and so we'll be doing one seminar a month. Our next one is on July 11th at 2 p.m. and that's going to focus on elder abuse, what you need to know, how to report it, how it's handled, and what the prosecution of that looks like in our county. So you can go ahead to our website and register for that, but we're getting them mapped out one a month through the rest of the year. So if you have a topic that you'd like to hear about, please let me know as well. So thank you all for joining us today. And thank you so much again, Mr. Young, for your wonderful presentation. And I hope everybody has a wonderful evening.
Thank you, Martha. Thanks for doing the series. It's very important.
Thank you so much.